Hello and welcome again. Today's installment of our discussion with this PowerPoint narrative is about the Constitution and our chapter discussion regarding same. The Constitution, the United States Constitution provides the legal framework for our federal government and the authority that the government has to regulate business activities. Our course is entitled The Legal Environment of Business, and business regulation is obviously covered through the United States Constitution. There are 7 articles in the Constitution. The first 3 articles establish the legislative, executive, and judicial branches of the government. We've talked about these branches earlier in the course. The legislative branch, of course, relates to legislation, bills, enactments. The executive deals with the president, whose office is in charge of executing the laws, making sure that the laws are carried out, and of course the judiciary, which is composed of all of the courts. The legislative, executive, and judicial branches of government were created by the Constitution. Article 1 of the Constitution contains the so-called Commerce Clause. This clause is the constitutional framework that gives the power to the government to regulate business. It gives the constitutional authority to provide for oversight and regulatory matters that relate to business. Article 4 ensures one nation versus individual states, one nation being the United States, will provide the framework for citizenship and commercial activities. This article contains the so-called full faith and credit clause and privileges and immunities clause. Now, when I mention the term clause or clauses, they are sentences or fragments of sentences within the described constitutional body itself. There have been 27 amendments to the Constitution. What's interesting is that only 17 amendments have been approved since 1791. All of this information, which I'm putting together here on this PowerPoint, is contained within the chapter readings. So nothing I'm providing here today or in other installments goes beyond what your studies have required you to consider and to prepare for in this course. The separation of powers between levels of government is known as federalism. There's a concept that's brought out in your textbook. It's a darkened, bolded, printed term called federalism. That relates to the separation of powers. The separation of powers. The concept recognizes that each level of government has its own authority. And power to provide for the outcome of its business or its actions. Under the Supremacy Clause, courts may be called upon to decide if a state law is invalid because it conflicts with a federal law. In other words, when there is conflicting law involving the same source, the federal law will carry the day, so to speak. In other words, it will trump the state law in terms of the authority. In Article 6, it is clear that the Constitution is supreme it should be over all laws, and that the federal law is supreme over a state or local law. Under the Supremacy Clause, The order of priority is this. First, the Constitution. It has supreme authority. It's the ultimate source of the laws of the United States, both the United States law and the respective states' law. U.S. laws, state laws such as the state of Illinois, the state of Indiana, the state of Wisconsin, those states have laws, and likewise local or municipal laws. So the order is very clear. The U.S. the U.S. Constitution, the U.S. laws, state laws, and local laws and ordinances in that order or rank. A federal law will preempt a state law if there is any overlap. The concept of preemption applies not only to federal statutes, but to the rules and regulations of federal administrative agencies. Now, there's a sidebar, and I've encouraged you to examine very closely in your textbook these sidebar references. Sidebar 6.1 should be studied and carefully understood regarding this point. Let's talk again about preemption. State laws are preempted by federal laws when they involve the same activity or subject. For example, and this is something that's not in your casebook, but I want to use it as an example, the Federal ERISA Act. That stands for the Employment, Retirement, Income, and Security Act. It was passed by Congress in 1974. It will preempt state common law contract law. So if a state common law contract matter involves issues that relate to or are covered under the ERISA Act, then the ERISA Act will take priority. It will trump, so to speak, the state common law because it has been preempted by the federal preemption provision. Another example would be the Clean Water Act. The Federal Clean Water Act will preempt state laws that cover out-of-state sources of water pollution. So please understand the concept of preemption. The Supremacy Clause will establish the priority of the various laws and their sources. The preemption clause will allow for federal law to preempt or take priority over a state law covering the same or similar subject matter or activity. Let's talk about the Commerce Clause. Under the Commerce Clause, Congress shall have the power to regulate commerce, and that's with federal nations and among several states and with the Indian tribes. It comes right out of the Constitution. The Commerce Clause gives the federal government power to regulate business activity. And the Commerce Clause regulates foreign commerce, interstate commerce, the impact on interstate commerce, and also the limitation on federal authority. Under Article 1, Section 10 of the Constitution, no state shall pass any law impairing the obligation of contracts. This is the phrase or the section that is known as the Contract Clause. The Contract Clause regulates state and local government. It does not restrict the federal government's power to impact contractual relations. Okay, let's talk about the Bill of Rights. The first 10 amendments are commonly known as the Bill of Rights, and they establish a variety of important protections. At the conclusion of this PowerPoint presentation and narrative, we're going to re-examine the Bill of Rights in a little bit more detail with an order of what each of these 10 amendments include with the subject matter. But we're going to cover them by just a general overview in the next few minutes. So let's start with the First Amendment and the First Amendment's protections. The First Amendment states that Congress shall make no law respecting an establishment of religion, and that's known as the Establishment Clause, or prohibiting the free exercise thereof. And that phrase or clause is known as the Free Exercise Clause. These clauses guarantee freedom of religion through the separation of church and state. This amendment, let's talk about the First Amendment, freedom of speech. This amendment does not apply to private action. Further, freedom of speech is not absolute. So the First Amendment relates to freedom of speech as well. And I'll break down the First Amendment in a little bit more detail shortly. But the Supreme Court has held that the First Amendment protects picketing in some or in certain occasions when it pertains to a matter of public concern. Public issues of concern fall within the general protections of First Amendment free speech. The First Amendment states that Congress shall make no law, also is my phrase, abridging the freedom of the press. Let's talk about the Second Amendment. It relates to the right to possess guns. The Fifth Amendment includes, as your textbook indicates, the so-called taking clause. The taking clause of the Fifth Amendment to the Constitution allows the government to take specific recourses away from private owners for public use upon the payment of just compensation. There's a term that you should be aware of. It's called eminent domain. Eminent domain means that the government can take, in some instances, private property for public use upon paying just compensation. And the authority or the power to do so is within the Constitution, the Fifth Amendment in particular. Also under the Constitution, we have the 14th Amendment. Now this is beyond the first 10 amendments, the so-called Bill of Rights. And these phrases are contained within the 14th Amendment. Equal protection and due process of law. These terms have generated tremendous amounts of litigation over the years and Supreme Court decisions. And by the way, all of these matters involving the Constitution fall under federal law and the authority of the United States Supreme Court to decide what meets or does not meet so-called constitutional muster. State courts do not have any authority or jurisdiction to rule on federal constitutional matters. That remains well within the purview of the United States Supreme Court. Let's talk a little bit more in general about the 14th Amendment. The 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's what the 14th Amendment is, and it contains those two pillar provisions: due process and equal protection of the laws. The term due process of law is not easily defined. Your textbook authors clearly note that. The term describes fundamental principles of liberty and justice. That's a description. Due process means, and it's been interpreted as, having fundamental fairness and decency. Due process is a restraint on the government for acting in a manner that is arbitrary, capricious, or unreasonable. The clause does not prevent, however, private individuals or companies from acting in an arbitrary or unreasonable manner. The Due Process Clause applies only to governmental bodies. In fact, when you look at the Constitution and understand the basis and the underlying motivation to have it, it is a document that spells out rights that emanate from the government's actions against others. The Constitution literally is a document that provides for rights against what the government can do with respect to individuals and others. When I say others, companies and persons within that legal definition. And persons will entail corporations. And we'll talk about that later in the corporate section of the course. But I wanted to point out just here in passing that the Constitution applies to the public, and it's a redress against governmental power and authority, but it does provide for the process and the rights that individuals have that are certainly covered under the Constitution and part of ongoing discussion, analysis, and sometimes litigation. The Equal Protection Clause of the 14th Amendment contains this idea, and it's an ethical one, that the law should not treat people differently without appropriate rationale. There are three primary tests to determine application of the Equal Protection Clause. I'm not going to examine you or test you in your quizzes or your midterm or your final exam on these particular points of constitutional analysis, but I did want you to have just a general overview understanding of the standards. And the standards would involve minimum rationality, a quasi-strict scrutiny, and strict scrutiny. And if you want to look at that in more detail, again, reference your sidebar sections of your text, and this is section sidebar 6.13. Let's talk again about the First Amendment, which I said I would recap our discussion with toward the end. The First Amendment guarantees the freedom of religion, speech, press, and the right to peaceably assemble peaceably and to petition the government. So if anyone were to ask you what are the 5 protections of the First Amendment, they are the freedom of religion, the freedom of speech, the freedom of the press, the freedom for assembling peaceably, and the freedom to petition the government. The Second Amendment relates to, as I mentioned earlier, the right of people to keep and bear arms. Keep and bear arms. That's the Second Amendment to the Constitution. The Third Amendment prohibits in peacetime, note the term in peacetime, the lodging of soldiers in any house without the owner's consent. The Fourth Amendment, which we're actually going to talk about in much more detail when we learn about criminal law, prohibits unreasonable searches and seizures of persons and property. So we'll talk more about the Fourth Amendment and its protections when we get to the criminal law section of our course. The Fifth Amendment, as mentioned earlier, as it relates to fair payment for private use, the concept of eminent domain, but the Fifth Amendment guarantees the right to indictment by a formal accusation. That's from a grand jury for or to the due process of law and to fair payment when private property is taken for public use. The Fifth Amendment also prohibits compulsory self-incrimination, and double jeopardy, which means trial for the same crime twice. Now, you may have heard the phrase, "I'll take the fifth." Well, the fifth, it means the Fifth Amendment right not to self-incriminate yourself or self-incriminate oneself in a legal proceeding. The Sixth Amendment guarantees the accused in a criminal case the right of a speedy and a public trial by an impartial jury and with counsel. The Seventh Amendment guarantees the right to a trial by a jury in a civil case involving at least $20 or more. At least $20. So, in a criminal case, you have a constitutional right to a trial by jury. In a civil case, you are guaranteed the right to a trial by jury before a impartial panel of one's peers, forming a jury insofar as the amount in controversy exceeds a threshold level of $20. The Eighth Amendment prohibits excessive bail and fines as well as cruel and unusual punishment. The Ninth Amendment establishes the people have rights in addition to those specified in the Constitution. So the Constitution spells out all these different phrases and clauses, and it has different provisions, but the Ninth Amendment notes that people have rights in addition to those spelled or specified within the Constitution. The 10th Amendment establishes that those powers neither delegated to the federal government nor denied to the states are reserved to the states and to the people. All this, of course, is for educational purposes only. I hope you've enjoyed this presentation and gives you some further insight and understanding regarding our section of the Constitution as it relates to the study of the legal environment and regulation of business. Thank you.